So my overall reaction is that, based on my belief, is that the Senate had the jurisdiction to try the president, and the president, at least a compelling case was made against him, that it will be very difficult ever again to impeach a sitting president, because the evidence was so strong in this case. It allowed partisanship and politics to come into what should also be a judicial process.
Explain to me, if you would, Professor Kastenberg, how the Republican senators reached the view that the Senate didn't have jurisdiction to try the president, when Article 1.3 of the Constitution says the Senate has jurisdiction to try the president.
Well, so there's a type of reading of the Constitution, which is what you call strict textualism. And the view there is that if the Constitution, if the framers of the Constitution wanted to extend jurisdiction to former presidents or former cabinet officers, it would have clearly stated so in the Constitution. But my disagreement with them on that point is that decision has been made twice before, once with Senator William Blount and once with Secretary of War William Belknap. And unlike Blount, Belknap, or anyone else who's ever been impeached in a trial other than Andrew Jackson or Bill Clinton, is that the president is the sitting commander-in-chief and receives a lifetime pension from the people of the United States, which comes from the same pot of money that retired military members receive their pensions from. And retired military members are always subject to be recalled, including for the purpose of a court-martial under American law. Most Americans don't understand that unless they've served in the military. Well, the president's commander-in-chief of the armed forces. He's not a military member. Of course, he can't be court-martialed. Only service members can be. But his pension comes from the same place that retired service member pensions come from. And so I think that the Republicans who took the strict textualist view misread the very law that they've supported when it's come to the United States military.
When a US senator decides whether to acquit or convict a president in an impeachment trial, are they acting in a judicial capacity where they're expected to act impartially and in good faith, or are they entitled to take political factors into account?
Well, here's the thing. The United States Supreme Court has indicated in several decisions that the Senate has judicial power to it. If you look at the old Teapot Dome scandal case under Warren G. Harding, it's clear that the United States Supreme Court in 1927 found an inherent judicial power in the Senate. They did so in a case called Vare, and Vare had to do with the seating of a senator. So I believe, and the overwhelming number of my academic peers insist upon, that with that judicial power comes judicial responsibility. And I've done research, I wrote a book on the impeachment effort against Justice William O. Douglas in 1970. He was a Supreme Court justice, and also on the Nixon impeachment. And what you find there is many senators are acting responsible, and they're telling the public, I haven't made my mind up. I have to be fair and impartial to Richard Nixon or William O. Douglas. But what's happened in our modern era is that senators like Lindsey Graham, as an example, who is a lawyer and admitted to the bar and a retired Air Force officer on top of that, has made the point that he's not going to follow that rule, that basic norm that's been around for over 200 years, and they're going to act politically rather than judicially.
Finally, Professor Kastenberg, is an acquittal by the US Senate a declaration of innocence so that President Trump can now turn around to everybody and say, I'm innocent of inciting insurrection? Or is it merely the fact that the burden of proof or the standard of proof wasn't demonstrated to a satisfactory number of senators?
It's the latter. And people, some of my students have asked me, and others have asked me, does double jeopardy apply? And the answer to that is no. The Attorney General of the United States or the Attorney General of Washington, D.C. can seek to indict President Trump and actually try him in a criminal trial where the standard of proof is the highest in American law beyond a reasonable doubt. But the Senate standard of proof is malleable. It can be whatever the individual senator believes it to be. And so we don't know what the 100 varying standards of proof were in this trial, but in an actual criminal trial, we would know what the standard of proof was.
Do you think there'll be political ramifications for the 7 Republican senators who voted in favor of convicting President Trump?
Oh, I absolutely do. I think that for those who are seeking office again in re-election, they'll be primaried. I don't know if the primaries their challengers in the primaries will succeed, but I do think there'll be political ramifications that way, and I think there's possible ramifications in committee assignments as well. I think that senators like Senator Lisa Murkowski and Senator Susan Collins are generally safe. They're long-serving, United States senators, but Senator Ben Sasse and Senator Cassidy from Louisiana, I believe that they're the ones who are most at risk at being primaried and having their committee assignments tinkered with. Senator Burr and Senator Toomey are leaving, and I don't think Senator McConnell himself will attempt to interfere with them.